Hello everyone. In today's presentation, we are continuing with certain other miscellaneous important provisions. Through various case laws, it is made clear that both session courts and high courts have the original jurisdiction to grant bail at the first instance. The session's first approach is a guideline and is not mandatory.
Section 12 of the Juvenile Justice Act does not make any difference between heinous offences, serious offences, and petty offences. Therefore, in all the cases, a child in conflict with law is entitled to bail unless the proviso is attracted against him. Even though Juvenile Justice Act has been amended multiple times and the juvenile above 16 years in age can be tried as an adult by the children court. However, there is no amendment in respect of the consideration which is to be taken into account for the bail of the juvenile. Section 12 of the Juvenile Justice Act make the bail of the juvenile mandatory, and the ground on the basis of which his bail application can be rejected is also to serve the best interest of the juvenile himself. Therefore, the bail of a juvenile can be rejected only if the court comes to a conclusion that the release on bail will adversely affect the interest of the juvenile. Now we would learn about successive or second bail application in case of juvenile. If a new point has been raised in the second bail application, the court or the board has to take note of the new point. The new point may be about the perceptible change of circumstances or the fresh ground that may has arisen since the dismissal of the earlier petition. Now the question arises whether the complainant or the victim need to be heard before considering bail plea of a child in conflict with law. As we know, Juvenile Justice Act prioritizes rehabilitation and reintegration of the child. Further, bail decisions are focused on the child's welfare, not on the adversarial right of the complainant. As such, it can be said that victim role is limited and the participation of the victim is discretionary, not mandatory.
It may be noted that bail power are not exclusive to Juvenile Justice Board. Though the primary authority for grant of bail is Juvenile Justice Board, yet session courts and high court also act as safeguard to ensure justice, liberty and protection of the juvenile justice.
Now we would try to understand if section 436A of the erstwhile CRPC or section 479 of the BNSS is applicable to Juvenile Justice Act. As per section 436A of the CRPC, it allowed the release of the under trial prisoners on bail if they have already spent half of the maximum sentence in detention. Similar provision is also retained in section 479 of the BNS 2023. As per the various cases that have been decided so far, these provisions are not applicable to Juvenile Justice Act. However, non-application of such provision to Juvenile Justice Act does not mean that juvenile cannot be repatriated to his family or community at all. But such order can always be made even before completion of such period in individual cases based on the fact of the case. Now another question arises if Juvenile Justice Board is required to consider preliminary assessment report before passing any final order on a bail application. Now it has been settled through various case laws that a complete preliminary assessment under section 15 of the Juvenile Justice Act is neither required to be done nor considered for any decision on the bail application. Now coming to the cancellation of bail. As far as Juvenile Justice Act is considered, no provision for cancellation of bail is provided. However, General principle of law allows it for certain circumstances. Bail granted can be cancelled if juvenile misuses liberty, commits another offence while on bail, violates bail condition, or threatens witness or obstructs justice. In such cases, any person aggrieved by the order passed by Juvenile Justice Board can prefer an appeal before the Session Court, and against an order passed by Session Court, a revision petition can be preferred under Section 1(2) of the Juvenile Justice Act. With this, the series on bail to a juvenile concludes. This series would be continued further to explain other important aspects of juvenile justice in detail. This would be helpful for all the individuals, including professionals in legal field. Do continue to watch this series and share your feedback by way of comments.